Amy Pittman here with Pittman Law Office, and we were talking today about estate planning and married couples, things that you do not want to overlook as a married couple. One being beneficiary designations. Make sure if it's an asset that's in your individual name that your spouse, if that's who you want it to go to, is actually named as beneficiary. So that's like retirement accounts, life insurance, annuities. Sometimes we have individual bank accounts, but we want to make sure that that does not go to probate. So make sure that you have your spouse as a beneficiary. The other thing to consider is what happens if you both die at the same time. Now, it doesn't happen that often, but we have had recently clients have died within days of each other or a couple months of each other, and they did not have secondary beneficiaries. They did not have beneficiaries on accounts that they were owned jointly. So make sure that you're planning as if you would die at the same time. Again, not that that happens that often, but we don't want that probate to occur or the confusion and being overwhelmed for the loved ones that are left to try to figure out everything. Also make sure you're planning for incapacity. So I know part of our estate plan, I know with clients of ours, they're having a durable power of attorney, and that document allows the spouse to make financial day-to-day decisions for the other spouse if that spouse for some reason cannot make a decision. Maybe they're incapacitated, maybe they're just getting older and slowing down. So make sure you have a power of attorney that allows someone to handle your financial affairs. And then you have a successor to that person. Because again, what if you're in the same accident? So make sure in your power of attorney, you have a backup agent to your spouse. And that goes the same for your healthcare surrogate. Having spouse as your healthcare surrogate, we always recommend you have a successor just in case your spouse is unable to make the medical decisions for you. And then the other thing is if you are the one handling your finances, so you're the spouse that pays the bills, that knows how to pay the bills, where's the passwords, how to get access to the bank accounts, you want to make sure that your other spouse, that your surviving spouse, or the well spouse, we call it, the one that's not incapacitated, knows how to handle those affairs, or at least knows where to go to get the information. Having a list of assets, how are those assets titled? How do you get access to them? Online? Do you get financial statements in the mail? And then also, how do you pay your bills? Are we going directly to the website? Does it come out of our bank account, or does it get paid by a credit card? And then password. So don't leave the surviving spouse or the spouse that's not incapacitated overwhelmed with this process if you all of a sudden get sick and are unable to make those decisions. We also want to make sure, you don't assume, okay, everything goes to spouse. So the way assets are titled is going to control. So just because you're married does not mean your spouse is automatically going to receive an asset. It's all about how the asset is owned and if there's a beneficiary designation. So make sure that all of those accounts, assets you review, regularly. I would say at least once a year to make sure that they're titled properly. So again, estate planning with married couples is a little different. A lot of times planning comes into play only when the first spouse dies, but we really want to make this clear. So if you both die at the same time or both become incapacitated at the same time, your loved ones, the next people in line, are prepared for that. So if you have questions, obviously you can contact us here at Pittman Law Office. Our consultations are complimentary, but again, this is information for Florida residents. We only practice here in the state of Florida. But again, don't overlook your estate plan if you're married. And that's for any state. Make sure that you're staying current with your beneficiary designations, the way your assets are titled, and that your estate plan is in line with that. All right, that's estate planning the pink way.